Tell me the truth, I know you did. I will get you, sure it's justice. Tell me the truth, I know you did. I will get you, sure it's justice. Sometimes you get out of my love, sometimes you get out of my love. Justice online, online, online. Justice, sometimes you get out of my love, sometimes you get out of my love. Justice online, online, online. Find a way to keep your faith. Don't run away, stand your ground.
Ikaw ay inaaresto sa sala pagnanakaw. ikaw ay may karapatang manahimik o magsawalang kibo. Ano man ang iyong sasabihin ay maaaring gamitin pabor o laban sa iyo sa anumang hukuman. Ikaw ay mayroon ding karapatang kumuha ng tagapagtanggol na iyong pinili at kung wala kang kakayahan, ito ay pagkakaloob sa iyo ng pamahalaan. Naunawaan mo ba to?
Oo.
All rise.
For the trial under Rule 119, Section 1, the time to prepare for trial. After the plea of not guilty is entered, the accused shall have at least 15 days to prepare for trial. The trial shall commence within 30 days from the receipt of pre-trial order. Under Section 2 on the continuous trial until terminated or postponement, trial once commenced shall continue from day to day as far as practicable until terminated. It may be postponed for a reasonable period of time for good cause. The court shall, after consultation with the prosecutor and defense counsel, set the case for continuous trial on a weekly or other short-term trial calendar at the earliest possible time so as to ensure a speedy trial. Under no cases shall the entire trial period exceed 180 days from the first day of trial, except as otherwise authorized by the Supreme Court. The time limitation provided under the section and the preceding section shall not apply when special laws or circulars of the Supreme Court provide for a shorter period of trial.
Your Honor, the accused was experiencing unsound mental condition that we need to take into consideration and put him on an examination to be ascertained if he is fit to attend the trial. Under Section 3, Paragraph A1, Subparagraph A of Rule 119 provides that when the periods of delay shall be excluded in computing the time when any period of delay resulting from another proceedings concerning the accused, which includes delay resulting from an examination of the physical and mental condition of the accused.
It's driving me crazy.
The other grounds for exclusion are the following. Any period of delay resulting from other proceedings concerning the accused, including but not limited to the following. Number 1. Delay resulting from an examination of the physical and mental condition of the accused. Number 2. Delay resulting from proceedings with respect to other criminal charges against the accused. Number 3. Delay resulting from extraordinary remedies against interlocutory orders. Number 4. Delay resulting from pretrial proceedings, provided that the delay does not exceed 30 days. Number 5. Delay resulting from orders of inhibition, or proceedings relating to change of venue of cases or transfer from other courts. Number 6. Delay resulting from a finding of the existence of a prejudicial question, and Number 7. Delay reasonably attributable to any period, not exceed 30 days, during which any proceeding concerning the accused is actually under advisement. Any period of delay resulting from the absence or unavailability of an essential witness. For purposes of this subparagraph, an essential witness shall be considered absent when his whereabouts are unknown or his whereabouts cannot be determined by due diligence. He shall be considered unavailable whenever his whereabouts are known but his presence for trial cannot be obtained by due diligence. Any period of delay resulting from the mental incompetence or physical inability of the accused to stand trial. If the information is dismissed upon motion of the prosecution and thereafter a charge is filed against the accused for the same offense, any period of delay from the date the charge was dismissed to the date the time limitation would commence to run as to the subsequent charge had there been no previous charge. A reasonable period of delay when the accused is joined for trial with a co-accused over whom the court has not acquired jurisdiction, or, as to whom the time for trial has not run and no motion for separate trial has been granted. Any period of delay resulting from a continuance granted by any court motu proprio, or on motion of either the accused or his counsel, or the prosecution, if the court granted the continuance on the basis of its findings set forth in the order that the ends of justice served by taking such action outweigh the best interest of the public and the accused in a speedy trial.
Your Honor, I move to file a motion for continuance on the ground that since my client is exhibiting previously a mental incompetence, the time given to us will give us reasonable time to prepare for the trial.
Section 4. Factors for granting continuance. The following factors, among others, shall be considered by a court in determining whether to grant a continuance under Section 3F of this rule. A. Whether or not the failure to grant a continuance in the proceeding would likely make a continuation of such proceeding impossible or result in a miscarriage of justice, and whether or not the case taken as a whole is so novel, unusual and complex, due to the number of accused or the nature of the prosecution, or that it is unreasonable to expect adequate preparation within the periods of time established therein. In addition, no continuance under Section 3F of this rule shall be granted because of congestion of the court's calendar or lack of diligent preparation or failure to obtain available witnesses on the part of the prosecutor.
Section 12 of Rules of Court, the application for examination of witness for accused before trial, when the accused has been held to answer for an offense, he may, upon motion with notice to the other parties, have witnesses conditionally examined in his behalf. The motion shall state the name and residence of the witness, the substance of his testimony, and that the witness is sick or infirm as to afford reasonable ground for believing that he will not be able to attend the trial, or resides more than 100 kilometers from the place of trial and has no means to attend the same, or that other similar circumstances him from attending the trial. The motion shall be supported by an affidavit of the accused and such other evidence as the court may require. Under Section 13, examination of defense witness how made. If the court is satisfied that the examination of a witness for the accused is necessary, an order will be made directing that the witness be examined at a specified date, time, and place and that a copy of the order be served on the prosecutor at least 3 days before the scheduled examination. The examination shall be taken before a judge, or, if not practicable, a member of the bar in good standing so designated by the judge in the order, or if the order may be made by a court of superior jurisdiction for an inferior court to be designated therein. The examination shall proceed notwithstanding the absence of the prosecutor provided he was duly notified of the hearing. A written record of the testimony shall be taken. Under Section 14, bail to secure appearance of material witness when the court is satisfied upon proof or oath that a material witness will not testify when required, it may upon motion of either party order the witness to post bail in such sum as may be deemed proper. Upon refusal to post bail, the court shall commit him to prison until he complies or is legally discharged after his testimony has been taken. Under Section 15, examination of witness for the prosecution. When it satisfactorily appears that a witness for the prosecution is too sick or in fear to appear at the trial as directed by the order of the court or has to leave the Philippines with no definite date of returning, he may forthwith be conditionally examined before the court where the case is pending. Such examination in the presence of the accused or in his absence after reasonable notice to attend the examination has been served on him shall be conducted in the same manner as an examination at the trial. Failure or refusal of the accused to attend the examination after notice shall be considered a waiver. The statement taken may be admitted in behalf of or against the accused.
The public prosecutor presented this witness for his direct examination. The defense counsel conducted cross-examination. Thereafter, public prosecutor conducted redirect examination, followed by cross-examination by the defense counsel. Thereby, the testimony of the witness was terminated. The public prosecutor manifested that he has no more witness to present and he is ready to formally offer his evidence. He formally offered his evidence where the defense counsel made his comment thereto.
Your Honor, we move to file a motion of leave of court for the filing of temporary evidence.
Granted, the public prosecutor is hereby given same period of 15 days to file his comment, and after which the incident is submitted for resolution.
Under Rule 119, Section 17, discharge of accused to be state witness. When two or more persons are jointly charged with the commission of any offense, upon motion of the prosecution before resting its case, the court may direct one or more of the accused to be discharged with their consent so that they may be witnesses for the state when, after requiring the prosecution to present evidence and the sworn statement of each proposed state witness as a hearing in support of the discharge. The court is satisfied that under Section 18, discharge of accused operates as acquittal. The order indicated in the preceding section shall amount to an acquittal of the discharged accused and shall be a part of future prosecution conviction for the same offense. Unless the accused fails or refuses to testify against his co-accused in accordance with his sworn statement, constituting the basis for the discharge.
Section 23 of Rule 119 of Criminal Procedure, demurrer to evidence. After the prosecution rests its case, the court may dismiss the action on the ground of insufficiency of evidence. Number 1, on its own initiative after giving the prosecution the opportunity to be heard. Or, number 2, upon the demurrer to evidence filed by the accused with or without leave of court. If the court denies the demurrer to evidence filed with leave of court, the accused may adduce evidence in his defense. When the demurrer to evidence is filed without leave of court, the accused waives the right to present evidence and submits the case for judgment on the basis of the evidence for the prosecution. Motion for leave of court to file the demurrer to evidence shall specifically state its ground and shall be filed within a non-extendable period of 5 days after the prosecution rests its case. The prosecution may oppose the motion with a non-extendable period of 5 days from its receipt. If leave of court is granted, the accused shall file the demurrer to evidence within a non-extendable period of 10 days from notice. The prosecution may oppose the demurrer to evidence within a similar period from its receipt. The order denying the motion for leave of court to file the demurrer to evidence or the demurrer itself shall not be reviewable by appeal or by certiorari before judgment.
Section 24. Reopening. At any time before finality of the judgment of conviction, the judge may, motu proprio or upon motion, with hearing in either case, reopen the proceedings to avoid a miscarriage of justice. The proceeding shall be terminated within 30 days from the order granting it.
Section 1 under Rule 120, Judgment. Judgment is the adjudication by the court that the accused is guilty or not guilty of the offense charged and the imposition on him of the proper penalty and civil liability. If any, it must be written in the official language, personally and directly prepared by the judge and signed by him, and shall contain clearly and distinctly a statement of facts and the law upon which it is based.
Under Rule 120, Section 6, Promulgation of Judgment. The judgment is promulgated by reading it in the presence of the accused and in any judge of the court in which it was rendered. However, if the conviction is for a light offense, the judgment may be pronounced in the presence of his counsel or representative. When the judge is absent or outside of the province or city, the judgment may be promulgated by the clerk.
Order. When this case was called, public prosecutor was present, and the defense counsel likewise. The complainant and the accused were present. How do you want to read the judgment? Do you want to read the whole judgment or just the depositive portion?
Your Honor, we prefer the dispositive portion.
Wherefore, this court finds the accused guilty beyond reasonable doubt.
Harigo et al. Versus People of the Philippines. The facts of the case. Petitioners Harigo, Tony, Jerry, and Jane were charged before the Metropolitan Trial Court of Manila for other deceits under Article 318 of the Revised Penal Code. August 1996, Manila, Philippines accused Gos Defraud, Haydon Company, Ltd, represented by Lil Wenping, in the following manner. By means of false manifestations and fraudulent representations which they made to said Lil Wenping to the effect that they have chattels such as machinery, spare parts, equipment, and raw materials installed and fixed in the premises of BGB Industrial Textile Mills Factory located in the Bataan Export Processing Zone. In Mariveles, Bataan, executed a deed of mortgage for a consideration amount in favor of ML Resources and Haydon Company, representing that the said deed is a first mortgage, when in truth and in fact the accused well knew that the same had been previously encumbered, mortgaged, and foreclosed by China Bank Corporation, causing damage and prejudice to said Haydon Company. Upon arraignment, petitioners pleaded not guilty to the charge. The prosecution's complaining witness, Lil Wenping, a frail old businessman from Laos, Cambodia, traveled from his home country back to the Philippines in order to attend the hearing held on September 9, 2004. Trial dates were subsequently postponed due to his unavailability. A motion to take oral deposition of Lil Wenping was filed, alleging that Ping was being treated for lung infection at the Cambodia Charity Hospital in Laos, and that upon doctor's advice, he could not make the long travel to the Philippines by reason of ill health. RTC granted the petition and declared the Metropolitan Trial Court orders null and void. The Regional Trial Court held that Section 17, Rule 23 on the taking of depositions of witnesses in civil cases cannot apply suppletorily to the case since there is a specific provision in the rules of court with respect to the taking of depositions of prosecution witnesses in criminal cases, which is primarily intended to safeguard the constitutional rights of the accused to meet the witness against him face to face. Upon denial by the Regional Trial Court of their motion for consideration, the prosecution elevated the case to the Court of Appeals. So the Court of Appeals decision, which held that no grave abuse discretion can be imputed upon the Metropolitan Trial Court for allowing the deposition taking of the complaining witness Lil Wenping. Court of Appeals denied petitioner's motion for consideration. The issue of the case is whether or not Court of Appeals erred in not finding that the deposition taking of the complaining witness in Laos, Cambodia is an infringement of the constitutional right of the petitioners to confront the said witness face to face. So the ruling is, yes, there is a great deal difference between the face-to-face confrontation in a public criminal trial, in the presence of the presiding judge, and the cross-examination of a witness in a foreign place outside the courtroom in the absence of a trial judge. In the aptly cited case of People versus Estenzo, the court noted the uniqueness and significance of a witness testifying in open court. Thus, the main and essential purpose of requiring a witness to appear and testify orally at a trial is to secure for the adverse party the opportunity of cross-examination. The opponent, according to an eminent authority, demands confrontation not for the idle purpose of gazing upon the witness or of being gazed upon by him, but for the purpose of cross-examination which cannot be had except by the direct and personal putting of questions and obtaining immediate answers. There is also the advantage of the witness before the judge, and it is this: it enables the judge as trier of facts to obtain the elusive and incommunicable evidence of a witness deportment while testifying, and a certain subjective moral effect is produced upon the witness. It is only when the witness testifies orally that the judge may have a true idea of his countenance, manner, and expression, which may confirm or detract from the weight of his testimony. Certainly, the physical condition of the witness will reveal his capacity for accurate observation and memory, and his deportment and physiognomy will reveal clues to his character. These can only be observed by the judge if the witness testifies orally in the court.
The case of People of the Philippines versus Roger Dominguez was happened on January 13, 2011. Benson Evangelista, a car salesman, was abducted in Cubao, Quezon City by a group of men, later pinpointed as the respondents herein. Evangelista's car remains were discovered the following day at Cabanatuan, Nueva Ecija. In connection with the incident, Mendiola and Parulan voluntarily surrendered to the Philippine National Police and executed extrajudicial confession identifying the brothers Dominguez, Raymond, and Roger as the masterminds behind the carnapping. This led to filing the information before the Quezon City RTC as an information against Mendiola and the respondents. The prosecution motions that Mendiola be discharged as an accused to become a state witness, then the court granted the motion. Thereafter, by a surprise turn of events, Mendiola was found dead on May 6, 2012. The issue here, whether or not the testimony of Mendiola during the discharge proceeding should be admitted as part of the prosecution evidence in chief despite his failure to testify during the trial proper prior to his death. The court rulings that the petition is meritorious, the instant petition is granted, and the resolution of the Court of Appeals are reversed and rescised. The testimony of Alfred Mendiola hereby reinstated because of under the Section 17 of the Rule 119 of the Rules of Court provides that discharge of accused to be state witness when two or more persons are jointly charged with the commission of any offense upon motion of the prosecution before resting in case the court with the commission of any offense upon the motion of the prosecution under the Section 17 of Rule 119 of the Rules of Court provides discharge of accused to be state witness when two or more persons are jointly charged with the commission of the offense upon motion of the prosecution before resting its case. The court may direct one or more of the accused to be discharged with their consent so that they may be witnesses for the state when, after requiring the prosecution to present evidence and the sworn statement of its proposed state witness at the hearing in support for the discharge, the court is satisfied that there is an absolute necessity for the testimony of the accused whose discharge is requested. Also, under the Section 18 Rule 119 of the Rules of Court makes it mandatory the state witness be presented during trial proper, and otherwise his failure to do so will render his testimony inadmissible. Section 18, discharge of accused, operates as acquittal. The order indicated in the preceding section shall amount to the acquittal of the discharged accused and shall be barred to future prosecution for the same offense unless the accused fails or refuses to testify against his co-accused in accordance with his sworn statement constituting the basis for the discharge.
People of the Philippines versus Sandigan Bayan. Facts of the case: the Office of the Deputy Ombudsman for Visayas charged Mayor Quintin B. Saludaga and Revenue Collection Clerk Artus E. Adriatico of Lavezaras North and Samar, together with Romeo de Luna, a private individual, for falsification of public documents penalized under Article 171 of the Revised Penal Code. The prosecution alleged that sometime in January 1999, Adriatico issued official receipt dated August 27, 1997 to De Luna, representing the latter's payment for his mayor's permit to operate as Pacquiao contractor. Conniving with Adriatico and De Luna, Mayor Saludaga allegedly issued and signed the mayor's permit also sometime in January 1999. The prosecution averred that Mayor Saludaga antedated the mayor's permit to confer on De Luna the status of a bona fide Pacquiao contractor. Both Mayor Saludaga and Adriatico allegedly knew that De Luna was not a licensed Pacquiao contractor when they issued the mayor's permit and the subject OR. The prosecution submitted that the respondents connive and mutually help one another in falsifying the subject OR and the mayor's permit to make it appear that De Luna was a bona fide Pacquiao contractor. The prosecution presented his witnesses during trial. The prosecution then rested its case and submitted its formal offer of evidence, which the Sandigan Bayan admitted. The respondent filed a motion for leave to file a demurrer to evidence. The Sandigan Bayan granted the demurrer. The prosecution filed to prove some of the elements of falsification of documents under Article 171 of the Revised Penal Code, namely, first, the offender is a public officer, employee, or notary public. Second, the offender takes advantage of his official position. And third, the offender falsifies a document by making untruthful statements in a narration of facts. In particular, the Sandigan Bayan found that the prosecution failed to prove the second and third elements. So the issue of the case is whether or not the Sandigan Bayan gravely abused its discretion when it granted the respondent demurrer. The issue of the case is whether or not the Sandigan Bayan gravely abused its discretion when it granted the respondent's demurrer. Ruling, no, the Sandigan Bayan did not gravely abuse its discretion when it granted the respondent's demurrer. Under Section 23, Rule 119 of the Revised Rules of Criminal Procedure provides, after the prosecution rests its case, the court may dismiss the case on the ground of insufficiency of evidence. On its own initiative, after giving the prosecution an opportunity to be heard, or on motion of the accused with prior leave of court. A demurrer to evidence is an objection by one of the parties in an action to the effect that the evidence which his adversary produced is insufficient in point of law to make out a case or sustain the issue. The party filing the demurrer challenges the sufficiency of the prosecution's evidence. The court's task is to ascertain if there is competent or sufficient evidence to establish a prima facie case to sustain the indictment or support a verdict of guilt. In criminal cases, the grant of demurrer amounts to an acquittal, and the dismissal order may not be appealed as this will place the accused in double jeopardy. Although the dismissal order is not subject to appeal, it may be reviewed through certiorari under Rule 65. Wherefore, the court dismissed the petition.
Leonora B. Ramando, petitioner, versus spouses Winston and Elenita Aldava and People of the Philippines, respondents, GR number 203583, October 13, 2014. Facts. An information was filed before the RTC charging Remando of the crime of estafa through the use of false manifestation and fraudulent representation. According to the prosecution, Remando enticed spouses Aldava to invest in her business under the assurance that it is stable and that their money would earn 8% monthly interest. Spouses Saldaba gave Remando a check in the amount of 500,000 pesos as investment in her business. In return, Remando gave spouses Saldaba 3 post-dated checks, one for 500,000 pesos and the other two for 40,000 each, and made them sign an investment contract with Multitel International Holding Corporation. Upon maturity of the checks, spouses Saldaba attempted to encash the same, but were dishonored for being drawn against its insufficient fund. This prompted spouses Saldaba to demand Remando to make good the said checks, but to no avail. Hence, they were constrained to file a criminal complaint for staff against her. In her defense, Remando denied that she enticed them to invest in her own business, as she had none. According to her, she only referred them to Multitel Investment Manager, and she only issued the 3 post-dated checks to accommodate them while waiting for the checks from Multitel. But when the latter issued the checks, spouses Saldaba refused to accept it, so he can be held liable in case of their investments fail. Meanwhile, spouses Saldaba also filed a criminal case against Remando for violation of Batas Pambansa Bilang 22 before the Metropolitan Trial Court of Manila, Branch 6. However, Remando was acquitted in BP 22 cases on the ground of reasonable doubt, with the declaration that the act or omission from which liability may arise does not exist. In a decision, the RTC acquitted Remando of the crime of estafa, but found her civilly liable spouses Saldaba in the amount of 500,000 pesos. Remando appealed to the Court of Appeals. In a decision, the Court of Appeals affirmed the RTC ruling. Remando moved for reconsideration. However, it was denied. Issue: whether or not the Court of Appeals correctly upheld Remando's civil liability in the estafa case despite her acquittal and exoneration from civil liability in the BP 22 cases. Ruling: the petition is without merit. The extinction of the penal action does not carry it with it the extinction of the civil liability where A. the acquittal is based on reasonable doubt as only preponderance of evidence is required. B. the court declares that the liability of the accused is only civil. And C. the civil liability of the accused does not arise from or is not based upon the crime of which the accused is acquitted. However, the civil action based on the delict may be deemed extinguished if there is a finding on the final judgment in the criminal action that the act or omission from which the civil liability may arise did not exist, or where the accused did not commit the acts or omission imputed to him. In this case, Remando's civil liability did not arise from any purported act constituting the crime of estafa, as the RTC clearly found that Remando never employed any deceit on spouses Saldaba to induce them to invest money in Multitel. Rather, her civil liability was corrected traced from an accommodation party to one of the checks she issued to spouses Saldaba on behalf of the Multitel. In lending her name to Multitel, she in effect acted as surety to the latter. As such, she may be held directly liable for the value of the issued check. Verily, Remando's civil liability to spouses Saldaba in the amount of 500,000 pesos does not arise from or is not based upon the crime she is charged with. And hence, the Court of Appeals correctly upheld that the same despite her acquittal in the estafa case. Essentially, while BP 22 case and an estafa case may be rooted from an identical set of facts, they nevertheless present different causes of action, which, under the law, are considered separate, distinct, and independent from each other. Therefore, both cases can proceed to their final adjudication both as to their criminal and civil aspects, subject to the provision on double recovery. For force, a ruling in a BP 22 case concerning the criminal and civil liability of the accused can be given any bearing whatsoever in the criminal and civil aspect of the related staff case, as in this instance. Wherefore, the petition is denied. Accordingly, the decision and the resolution of the Court of Appeals are hereby affirmed.
Sevilla versus People of the Philippines. Sevilla is a former councilor of Malabon City who was charged with a felony of falsification of public documents penalized under the revised penal code. After he stated in the Civil Service Form number 212 or the personal data sheet that he had no criminal case pending against him, when in fact he knew fully well that he is accused in a pending criminal case against the crime of assault upon an agent of person in authority. Sevilla admitted that he indeed marked the box corresponding to the no answer to the question whether he has no pending criminal case. However, he averred that he did not intend to falsify the PDS. He claimed that it was a member of his staff who actually prepared his PDS. He instructed Mendoza, the staff, to copy the entries in the previous copy of the PDS which he filed with his personal office. After the PDS was filed and delivered to him by Mendoza, Sevilla claims that he just signed the same without checking the veracity of the entries therein. Sandigan Bayan opined that Sevilla cannot be convicted of falsification of document under Article 171 of the revised penal code since he did not act with malicious intent to falsify the aforementioned entry in PDS. However, considering Sevilla's PDS was haphazardly and recklessly done, which resulted in the false entry therein, the Sandigan Bayan convicted Sevilla of falsification of public document through reckless imprudence under Article 365 of the revised penal code. Hence, the petition for certiorari. The issue is whether or not Sevilla can be convicted of falsification of public documents through reckless imprudence, notwithstanding that the charge against him in the information was for the intentional felony of falsification of public documents. So the Supreme Court rules that it is no. The proper designation of the felony should be reckless imprudence resulting to falsification of public documents and not falsification of public documents through reckless imprudence. They explained that the designation of falsification of public documents through reckless imprudence implies that reckless imprudence is not a crime itself but simply a modality of committing it, which is incorrect. Quasi-offense under Article 365 are distinct and separate crimes and not a mere modality of the commission of the crime. In explaining why, this is how the Supreme Court explained. The reckless imprudence is not a crime in itself, but a simple way of committing it and merely determining a lower degree of criminal liability that is too broad to deserve an unqualified assent. There are crimes that by their structure cannot be committed through imprudence. Example are murder, treason, robbery, malicious mischief, etc. Criminal negligence in our revised penal code is treated as mere quasi-offense and dealt with separately from willful offense. So, given this fact, the Supreme Court ruled out that under Article 365 of the RPC, reckless imprudence resulting in falsification of public document is punishable by arresto mayor in its maximum period to prison correctional in its medium period. In this case, taking into account the pertinent provisions of indeterminate sentence law, the Sandigan Bayan correctly imposed upon Sevilla the penalty of 4 months of arresto mayor as minimum to 2 years and 10 months and 21 days of prison correctional as maximum. The second issue is whether or not Sevilla's claim that his constitutional right to be informed of the nature of cause of the accusation against him was violated when the Sandigan Bayan convicted him of reckless imprudence resulting to falsification of public documents when the information only charged the intentional felony of falsification of public documents. So the answer of the Supreme Court is no. The rules on variance between allegation and proofs are laid down under Section 4 and 5 under Rule 120 of Rules of Court. The reckless imprudence resulting to falsification of public documents is an offense that is necessarily included in the willful act of falsification of public documents, the latter being the greater offense. As such, he can be convicted of reckless imprudence resulting to falsification of public documents, notwithstanding that the information only charged the willful act of falsification of public documents.
Ito yung mga victim. Yan po yung director natin. Yan. Ito yung mga bystander.
Siyempre po, eh nakama-zombie.
Baka yung security guard na Dhvsu ang mahuli ko.
Maging zombie happy. Pwede yung kainin.
May baka ka ba? Ay ka.